Welcome to Child Custody University Module 6, Creative Custody Orders. Child custody is a term regarding guardianship. It describes the legal and practical relationship between a parent or guardian and a child. Child custody consists of both legal and physical aspects. Legal custody is the right to make decisions about the child, and physical custody is the right and duty to house, provide, and care for the child. Parents normally have joint legal and physical custody of their children when they appear on a birth certificate. Decisions about child custody typically arise in proceedings involving paternity, divorce, annulment, and separation. In most jurisdictions, child custody is determined in a court, using a standard referred to as the best interests of the child. As any reasonable person might imagine, there can be a great source of disagreement due to varying value systems, as well as a multitude of child needs and differences. Once a disagreement occurs, many people will fixate on the rules. When a loophole exists, which most often does, conflict can escalate. People all believe they know what is best for their child. It could be that the arguments are equally valid and either or neither is just a matter of opinion, and 5 years from now, it will not matter. When individuals fixate on the rules, it inherently causes conflict because an offense is clear and it can cause one parent or both to feel threatened. This feeling can extend beyond the single and current incident. It can involve a fear of what the future looks like because of their perception of a pattern of past behaviors that seem congruent with what is happening currently. Then we fixate on the rules and loopholes are found, and to the races we go. This is why we take our time to create a quality order through protracted negotiations. It is a positive thing. Cookie-cutter custody agreements seem popular. They are easy for courts to dole out. They are formatted on most attorneys' laptops, I am sure. If you are lacking time, creativity, or true concern for the future of the children, why not settle on an order that offers generalities instead of specifics and much consideration, right? Future conflict is great for the business of attorneys, and great conversation for Thanksgiving dinners also. But if you are a parent who wants an agreement that enables cooperation in a very structured manner, cookie cutters don't work. If you want an agreement that does not require revisiting your checkbook for attorney fees every time an inevitable life change happens, such as age, cookie cutters don't work. If you want to avoid future conflict and avoid hashing each future detail in the moment, cookie cutter child custody orders do not work. Creative Custody Solutions is intended to instill a sense of control and creativity for parents to work in while still making agreements via for the recourse of the legal system, thereby rendering the agreements more acceptable to your legal representation. I am not a lawyer, and there is no legal advice or mental health advice given here. You can check with any industry professionals you need. Ultimately, you live out the terms of the stipulated agreement that you sign, not your attorney. Should you go through a trial, expect a cookie-cutter order with a variation or two for good measure. The bottom line is that if you want to create a peaceful future for your family, you know what the roadblocks are better than anyone. Taking action to mitigate problems with an agreement is prudent and some may say, very smart. You are looking to remove loopholes and future conflict. Sharing children is difficult enough on everyone already. Good luck and congratulations on your choice to be here. Looking for solutions is the right mindset. Having all of this discussion and then an agreement to take to a document service or an attorney to create filing paperwork and an order will save your money and time. First thing you need to do is to make a list of all the issues that need to be addressed. The list included here is very comprehensive. You should not be afraid to deviate by adding topics. You may also find that you do not need to include some. Use this list as a template. It is good to understand the other parent's perspective as well. If you can communicate with them about this, do so in a positive manner. You can put one topic on a piece of paper, for example, title 1 page, Schooling Concerns. On each page, make 2 columns. On the left side, write list of what you would like. On the right side, make a list of what the other parent wants. This 1-page, 2-column organization will separate issues as well as highlight the issues of concern. At the bottom of each page, write the conflict between yourself and the other parent. This is time-consuming, but this is better than arguing until the children are 18. With each issue and concern, remember, if the parents cannot agree on an issue, who has the final say? What is the tiebreaker plan? Avoiding future litigation is the goal. Do not invite future litigation by creating standoff situations. This can be done in several ways. Possibly there is a mental health professional that you both trust and will be available to offer recommendations, in the interest of the child, on the matters creating conflict. Ultimately, compromise will be necessary. Rather than a straight one-sided victory in the contention, consider that in order to negotiate successfully, both can sacrifice a bit with the child in mind. The one thing that is often recommended is not to allow the child to be responsible for the decision as a tiebreaker, while understanding and both parents considering the child's preference. A mental health professional can help sort this out and is likely cheaper and more peaceful than litigation. Remember, the idea is for the parents to make the best choices for the child. Here is a list of some possible types of physical custody. Sole custody. Only one person has physical custody of the child. The other parent usually has regular visitation rights. Joint physical. Both parents have the child about equal times. Bird's nest type of joint custody, where the child lives at a home and the parents go back and forth. The child gets the stability and the parents have the burden of moving back and forth. Split. 2 or more children and one parent is granted sole custody of one child and the other parent gets the other child. Alternating, often referred as divided. Child spends extended time with one parent and then an extended time with the other parent. Third party, child is placed with a third person. Fluid modifications. In any order, there can be a clause that can indicate the two parties can agree to modify the rules within, temporarily, so as to serve the interest of the children and the parties involved. The trick is to not make this clause an escape clause, to allow a legitimate contempt issue to become practically non-prosecutable. The other consideration is to void the order by both parties not following it. Is it enforceable if both parties are agreeing to be inconsistent with its terms? You can create a clause that says whatever you want. You will need to create a tie-breaking strategy that can apply to all mutual consent requirements. This can be an agreed-upon counselor or other seemingly neutral and responsible individual. Consider. Both parties agree that any term within this agreement can be modified temporarily by written mutual agreement that includes a start date and end date to the adjusted terms. It is agreed by both parties that any temporary adjusted agreement will not impact any other terms within the agreement other than those directly impacted by the temporarily modifying signed agreement. It is required that this temporary agreement contains the start and end date, as well as original dated signatures by both parties. It is further agreed that if there is a loophole or unforeseen conflict arising that causes irreconcilable conflict, both parties immediately would be required to revert back to the original agreement by the demand of either party, or they agree to use the agreed-upon tie-breaking strategy, include details, or indicate the strategy here. Child support. Many people are under the assumption that child support is based on how much time a child is with a parent exclusively. Another factor that is often considered is the imbalance of income between the two parents. The court reasonably assumes that a child is entitled to the benefit of the sum of both parents' income as the child would have, should the parents had remained together. The right to claim a child as a dependent on taxes is another factor that can affect a child's support amount. School. The school district the child will attend can be contentious. If one parent has primary physical custody, it can be assumed that the child will attend school in their school district. You need to get it clearly written into the agreement. With joint legal custody, it is necessary for parents to collaborate and agree upon educational issues. If the parents cannot agree on an issue, revert to the tiebreaker plan. Vacation time. With vacation time, it is often, and for good reason, a requirement to give notice to the other parent for a vacation time in advance. There can be defined time periods and/or a number of time periods that can be available. Commonly, this is all during a summer break from school that is defined the school schedule. To enable trips at other times of the year, such as Christmas time, this may enable an equal distribution rule regarding holidays. You can leave it up to negotiating in the future, but having some structure to define a process will reduce stress. Consider a 6-month request for permission clause for something like this. This will give you both time to negotiate and maybe require a decision. 30 days prior to ensure cheaper tickets and solid planning. The negotiations will likely require the requesting parent to give something up in exchange. Keep the children in mind. In the case that on the same day, both parents request the same time period, you have another problem. What is the timestamp? Child care. If your children are young and need child care, you need to define child care within your custody agreement. Provide information regarding the school's name, location, and cost. This may be factored directly into child support, or you may be required to submit monthly bills for reimbursement. Remember to find agreement to summer care. Often, if a parenting plan is week on and week off, the child care may only be needed half the time. The full-time cost will likely be required by the care center. Consider including family members as caretakers as well, especially when a child is too sick for daycare. Do all of this while being as specific as you need. All this is intended to avoid future conflict. Right of first refusal. This is an agreement that each party shall have the first right of refusal to provide care for the minor child, if the other party finds it necessary to have an alternate caregiver for more than a particular amount of time. 4 hours is common. I would think 7 hours would seem a better alternative. Step-parents can be considered an alternate caregiver or specified as otherwise. If your custody agreement used particular language and the other parent got called into work for a period longer than the time allocated, you would need to be contacted by the other parent and asked if you would like to keep the kids during that time. You would have the first right to the kids during that time. This is very important to you possibly. It doesn't require you to drop everything and tend to your children should you have work or prior commitment. It is your right to be the first to refuse this opportunity as you choose. Exchanges. It may be wise to state exactly when and where child exchanges will occur. You should state in the custody order which parent will be doing the transportation. It is often found more advantageous for the receiving parent to be responsible for the transportation. This will eliminate late deliveries as well as equally distribute responsibility. There is an issue of who else, other than the two litigants, will be allowed to deliver or be delivered to. Rather than being overly specific on this point, it may be wise to agree that we can agree that later under specific condition of an approval of the other parent. You can also consider that setting an amount of time to vet this new person, if it is necessary, could be included in an agreement. This is extreme and sometimes necessary. You may also want to include that, if necessary, permission once permitted can be revoked. What items will be expected to accompany the child during the exchanges? What will not be allowed to be taken with the children on exchanges? Does any of this even matter to you? It could be irrelevant, and it could be important. This is all for you to decide, and you need to make sure it is for the benefit of your child. Holidays. List the holidays either party is concerned with. Is National Bagel Day important? What if one of the parents owns a chain of bagel shops? Specify which holidays you're talking about, as well as how you want to share them. You should consider birthdays and not just the child's birthday. Mom, dad, grandparents, step-siblings all have birthdays. Respecting relationships is important. Finding a way to put these details in the stipulated agreement offers structure that reflects respect and family values. It is certainly not necessary but might be good for boundaries. For many holidays, some families alternate annually, while others have the same agreement each year with a split day. If you split the day, consider alternating the split day each year. If splitting the day, specify where the children will be the night before and the time you choose for the split. There can be some confusion that enters the discussion that is dependent upon which parent's house the holiday period starts and ends. I will use a 2-week Christmas break as an example. Assume you split the 2 weeks each year and it alternates. At some point one year, a parent will have 2 weeks in a row. Ensure that there is a different parent with the children at the end of the 2 weeks than the beginning. This maintains equal time with both parents. If have a week on and week off flow that is interrupted, at the end of the interruption, resume. Travel. The distance or the jurisdiction that travel is allowed by the other parent without permission of the other can also be stipulated to. Some questions to address are: What is the boundary? What is the notice due to the other party? Is permission from the other party necessary? What itinerary is due the other parent, if any, in order to take a trip? Permission to travel may seem extreme and could apply to locations or activities. International travel would be a reasonable event to require permission. It is all up to the two parties to agree. Medical. Medical insurance can be anyone's responsibility that you decide to agree to. It is usually shared equally. Emergency notifications should be required. Tiebreakers are necessary when parents disagree on medical choices. As in the discussion regarding education, a professional may be agreed upon to help be a tiebreaker. The type of professional used in this tiebreaker may be of a different type than in the education decisions, as that is what you choose. Medical doctors are in precarious positions with parents who disagree. If the welfare of a child is at risk and decisions are not made, the medical professional's hands may be tied and they could be required to use the government to take control. This is extreme, of course. Sometimes, though, it happens. Medical professionals concern themselves with liability, and respecting that is important. Out-of-pocket medical expenses. Include who will pay what portion of medical expenses. You can include time frames for when a bill needs to be received, as well as a proof of payment. A parent receiving a bill should forward to the other parent quickly if they expect payment accordingly. Late fees may accrue, and the offending late parent is the only one that should be responsible for the fees and not the parent who was responsible in their actions. Extracurricular activities. These include sports, dance, and many other activities. What is the basis for agreement? Is there a tiebreaker? Who pays for and how much? Splitting it in the same percentages as the state's child support calculator defines for the parties would be a reasonable position to take. A large concern is that these activities take place during a time offering both parents the ability to share in the child's experience if possible. Both parents should agree. Other expenses, cell phone bills, car insurance, and you can choose what else. Split in half, make the children responsible for a portion, and split the parents' portion 50-50, or according to the child support calculated percentage. Even if your child is not of age yet, allowing for the future in your stipulated agreement could help make the future go smoother. Communication. Hopefully this is not an issue for you, but in high conflict situations it can be important. Included on this topic should be the mode of communication. Email is a very good mode for many reasons. Receipt can be proven, and record is created, and can be referred back to clear up issues. Consider the time you choose to receive communications. Barring emergency 9/5 Monday through Friday may be a great time to limit communications to. There are co-parenting apps to help communication as well. You can shop around for those, and you might decide to include that in the agreement as well. The off-duty parent should be ensured they are able to communicate with the child, and parameters for that can be included in an agreement. You can set parameters on amount of calls, duration of a call, and times for calls. This is not to be too controlling, but to create boundaries. They can be limits, and they can be minimum allowed. For instance, calling your children 26 times in a 4-day weekend would seem to be stressful for a child. Religion. If parents do not have the same stance on religion, then a religion clause may be necessary. For example, it can be written that the children cannot be brought to a church or religious function unless the child wants to go, or that a child may practice any religious exercises only within a certain faith. Absence for work. Suppose that parent A is in the military, or in another job they may be called away for. If this occurs, should parent A's spouse, essentially a family member, have access to or a right to visitation with the child? Should the custody arrangement remain intact, or does parent B get the child by default? Relocation. This would likely require a complete change in an agreement. If you anticipate relocation, plan the order for it. There would be the agreement, and at the end, a clause that says, in the event that a parent relocates to a particular named location, the following details will supersede any prior agreements. Then there is essentially an entirely different and complete agreement. Overnight guests. This would not be necessary for most parents. Consider if there is a need for a restriction on overnight guests of the opposite sex or of a particular criminal background. Does a parent need to be married before the guest can stay overnight while the kids are present? This may be a consideration if events in the past have warranted legitimate concerns and is necessary to come to an overall agreement. While we're on the subject, is there a clause you want to include about how long a parent must be dating someone before the significant other can be introduced to the children? Rental properties. Is a parent permitted to rent or Airbnb a portion of their home, such as the basement, while the children are in their care? If one parent is considering this option and both parents do not agree, this needs to be discussed further and decided upon in the custody agreement. Special needs child. The challenges of divorce are compounded when you are raising a child with special needs. Several additional considerations must be factored into what is in the best interest of the child when determining child custody and visitation matters, as well as child support. It is important to have a detailed and comprehensive plan, clearly explained in the parenting plan, to ensure that the child's best interests are met. Special needs include those with 1. Chronic or life-threatening medical conditions. 2. Learning disabilities. 3. Attention deficit hyperactivity disorder, ADHD. 4. Autism. 5. Asperger's syndrome. 6. Psychological or behavioral disorders, depression, bipolar disorder, etc. In custody disputes involving special needs children, the court must be made aware of the child's individual issues, particular specialized needs and parameters of required care. The court will want complete information about professional diagnoses and whether both parents concur with the diagnosis and the proposed treatment for the child. The court may have to consider whether one parent is better trained to deal with the child's needs or whether one parent's schedule is better suited to meeting the everyday needs of the child. It is important to consider each parent's proximity to proper medical care in case of emergency, as well as proximity to the school that is best suited to handle the child's needs. Most of these factors, as well as additional concerns, must be considered before determining a visitation plan. Scheduling examples. Here are some examples of alternating scheduling options so that you can have a baseline of ideas to help complex negotiations. Linked to this audio is a PDF showing more details in a calendar format. Plan number 1. Alternate weeks. This is one of the most popular ways to split custody. It is simple and easy to remember. The kids spend 1 week at one house and then the next week at the other home. The transition from parent to parent most commonly occurs over on Friday, as depicted, but the week can start and end whatever day works best for your family. Plan number 2, alternate every 2 weeks. If transportation between the two homes is a big issue, a bi-weekly alternating schedule is also an option. While younger kids need more constant contact with their parent, older kids, such as in those in high school, are more likely to enjoy and adapt to this schedule. Plan number 3, alternate weeks with a midweek visit. If you feel that a week is too long to go without seeing your child, then you can arrange a visit sometime during the week. This could be as simple as having dinner together Wednesday night before they go back to their home for that week. Plan 4. Alternate weeks with a midweek sleepover. This is a secondary option to the midweek visit. You can turn dinner into an overnight stay, send your kid off to school, and have the parent for that week proceed to pick them up. As opposed to the visit option in Plan number 3, this method allows for the child to spend the entire night with the other parent. Plan number 5, alternating every X days. While alternating weeks is usually more common, you can make the duration at each house as short or as long as you want. From alternating every 2 days to every 10, it keeps the 50-50 split in mind, as whatever time one parent gets, the other parent gets as well. If your child is older, try and ask their opinion as to what they would prefer. Plan number 6, 2-2-3. Rotation. With this schedule, the week is divided up between the two parents. The children spend 2 days with parent A, 2 days with parent B, then 3 days of the weekend with parent A. The schedule for the next week then starts with parent B so that the children get to spend the weekend with the other parent. The obvious benefit is that both parents get equal amounts of weekend time, but moving every couple days between houses could prove stressful on the child. particularly if the two homes are not in close proximity with one another. Plan number 7, 3-3-4-4 rotation. The child spends 3 days with parent A, then 3 days with parent B, followed by 4 days with parent A, then 4 days with parent B. Essentially, this schedule creates an established home for the children Sunday through Tuesdays with parent A, and Wednesdays through Fridays with parent B. In order to keep time equal between the two parents, time spent with the parent is alternated on Saturdays. This schedule can help keep things less disruptive as there are established days of the weeks that the child is at each home, and the duration spent at each home is slightly longer than the 2-2-3 rotation. In addition, they get to see both parents more often than with alternating week schedules. Plan the rate, 2-2-5-5 rotation. This rotation is similar to Plan 17's 3-3-4-4 rotation, except that the established home for parent A is Sunday through Monday, while the established home for parent B is Tuesday through Wednesday. Thursday, Friday, and Saturday are then alternated between parents A and B. If parent A having all the Sundays is an issue, you could also start the rotation on Monday so that it is Friday, Saturday, Sunday that is alternating between the two parents. Plan number 9, 3-4-4-3 rotation. This schedule is a slight combination of Plan number 7 and Plan 8 above. The child spends 3 days with parent A, then 4 days with parent B, followed by another 4 days with parent A, and then 3 days with parent B, and the pattern then restarts. The result is that there is an established home 2 days of the week for each parent, and then the midweek can be alternated. As a reminder, no matter what schedule you choose, make sure that you are doing what is best for your family, especially your children. All of the above topics are intended to ensure you have perspective and feel the freedom to think outside of the box to address your specific family dynamics. There is no magic formula. Communication and creativity can usually bridge most divides. Often it is best to get the agreeable issues written first and then look at the disagreeable issues. Decide if you can give and take within a given issue, and if not, is there a way to give and take across issues? Try to avoid becoming entrenched with anything. When you are down to the final issues that separate yourself and the other party, begin discussing the impact of the choices on the child rather than the impact on the parents. One of the most common reasons that people disagree is simply the perspective in which they see the situation. It is important that without involving a trail, the parents are still in control. That is a big deal. Also consider the cost of a trial. The cost is more than the money, it is the time, the lost wages, the stress, and the impact on the children. This process often lasts almost a year, and then what? This doesn't even consider the unknown outcome. This expense should be factored in the negotiation equation. Keep talking and negotiating. When down to the final hurdle, ask yourselves if the amount of total expense lost in a trial is worth the point of disagreement and its consequence. If one parent is creating all-or-nothing position, the other has no choice. Try to encourage leaving the other with options. This is difficult. It is difficult because it is not natural to share time with your own child. Do not have high expectations for the outcome to offer anyone to go away with warm feelings. This process is about making the best of a bad scenario. This is the end of Module 6, Creative Custody Orders.